Almost got it. My apologies. Oh, I need to redact something that I failed to redact earlier. I mean, it doesn't actually matter if I redact it or not, but I'm going to do it as a courtesy because I'm nice. All right. I just had to remove an address. You know how it goes. Okay, guys. So this is my HRO. Here's what happened today. All right. If you don't know, why would it do this? If you don't know, as stated earlier in the stream, but I know not all of you were here at the beginning, there is a restraining order that has been issued against me. It's an ex parte restraining order. So in Minnesota, the process of obtaining a restraining order is you don't need the other person to know. What you do is you send your petition, you write up your petition to the court for a restraining order, and then you send it in, and a judge evaluates it independently. You can, as the petitioner, the requester of the restraining order, you can request a hearing. You are allowed to do that. Most people don't request a hearing. They want the order just issued. And then the onus falls upon the respondent, in this case, me, to, tell the court, hey, I want to fight this. So on June 26th, Aaron Imholt took out a restraining order against me, citing that he is afraid of me. And he specifically said he's afraid that I will get physically violent, which is funny. Like it's comical, and we're not gonna spend too much time discussing why it's comical at this point. But it's a pretty funny thing. He's like, I'm afraid he may become violent, which is weird because I haven't seen this person. I saw him on June 25th. I saw the back of his head in court. I don't think he even saw me. I didn't interact with him or do anything else. I was at court, to support Lady Rackets. It was supposed to be a sentencing hearing, but it turns out he picked up his release conditions enough and violated them enough to have an extension to October for his sentencing and to potentially blow up his plea deal, which is a big mess for him. That being said, I didn't interact with him. I didn't like yell to him or be like, "What up, dog?" Like I didn't do anything like that. Just went into the courthouse, went into a private room with Lady Rackets and waited. We entered the courtroom itself after everybody else, including him. And so there was no there's no interaction between any of us. But other than that, I haven't seen this person since April 30th of last year. And I'm happy to keep it that way. Like I've no desire to see him in person. In the ensuing time, he invited me to fight him at a boxing event, which I accepted immediately. He said, yes, I'll do it. And then he backed out and said I was a giant pussy for backing out. And I was like, wait, what? I don't remember doing that. I don't remember backing out. I said, yes, I would. But he said I backed out, which is very strange because I still would do it. Again, at a sanctioned event or whatever, like he had proposed. He proposed this sanctioned fight in a boxing ring at a gym or whatever, within the sport guidelines. And I said, cool, like, let's do that. That's fine. Now he also wanted to box 4 other people in the same day, like in a row. But his condition was that of the 5 people that he was going to box in a row, that I had to be one of them. He demanded that I was one of the people. Because I think he has some unresolved anger issues or whatever. Something like that. But I don't actually know his reasoning. But I had to be one of the people for the deal to go through. So I had to say yes, of course, because I didn't want to ruin 4 other people's day. So I said yes. But I've never threatened or proposed violence against him at all. It's such a wild thing. So now he's afraid of me being physically violent, which, okay. This will have to be resolved in court. So he issued it on the 25th. We had a hearing scheduled for July 15th. Kind of at the 11th hour, he hires an attorney. That attorney says he can't do July 15th. So they ask for a continuance. We oppose the continuance because this is bullshit. This is a bullshit claim, and he should be ready to go. And it's not my fault he hired a lawyer who couldn't make it on the date that we had that he knew when he hired the lawyer. This is not my problem. He has restricted my liberty with a restraining order. And, every day under it, there's a list of things I can't do. And so until that matter is resolved, I want the court to resolve it as fast as possible. That said, the current hearing date is on the 23rd, Wednesday, at I think 2 p.m. Central Time. And now this is what happened today. To everybody, pursuant to General Rules of Practice 105, notice is hereby given that the undersigned Ross W. Montgomery of the law firm of PCG Law hereby withdraws as counsel for petitioner Aaron Imholt in the above referenced matter. This notice of withdrawal has been served on all parties and proof of service has been filed with the court. Additional verification that respondent has been served through her counsel. I got burned by the fucking attorney. Calls me a woman. It's on the e-service system. Oh my gosh, what an asshole. Petitioner can be served in or notified of future matters at the following address. His telephone number is this. The undersigned has withdrawn effective July 21st, 2025, and any pleading or other documentation mailed or otherwise served after that date should be sent directly to petitioner at the above address. Dated July 21st, which is today, when I started today, 2025 by Ross Montgomery. That's it. So this was filed. First things first. Hey, Fat Sean, you dumb pile of adipose. He went after me and my lawyer for daring to oppose the initial continuance. Now, there will potentially be another continuance request. I will vigorously and thoroughly oppose it immediately as well. Because I'm the one restrained. Aaron is happy to have these delays and these continuances. They only benefit him. They don't benefit me at all. I don't need more time. I'll be ready to go on the 23rd. Aaron should be ready to go on the 23rd. He should have been ready to go on the 15th. He should have been ready to go on June 26th when he requested the HRO. He should have been ready to go at that time. That's what you should be doing when you're bringing a petition to the court to restrain someone's liberty, is you should be ready to defend it that day if necessary. Now, practically, of course, you're not going to have to defend it that day. But Fat Sean thought he was so smart, and he's like, you should be courteous to the other attorney. Hey, Nick used to be a lawyer. At least he used to be a lawyer. He should know you gotta be courteous to the other lawyers. Why would you do this? Why would you do this? Francis? Why you would do this is very simple. The proper response to frivolity is hostility. Frivolous lawsuits should be treated hostilely from jump. They should be. The litigant is dishonest. The petitioner, in this case, being the litigant that I'm talking about, the petitioner is dishonest. The petitioner is doing something for an improper purpose. It's on the face of the document. It's within all of the facts that the document contemplates, and it's within all of the facts that the document conveniently omits. There is no legitimate purpose for having a restraining order at all. None. Nothing that he has provided leads to the conclusion of a restraining order. And so it's frivolous, so it should be met hostilely. It kind of looks retaliatory, as people may or may not know. He is court ordered to not have any communication, interaction, or mentions of, directly or indirectly, Lady Rackets. And here's the crazy thing. This happened the day after his sentencing hearing, and his sentencing hearing didn't go well. His sentencing hearing didn't go well in large part because I and others submitted evidence that he was violating his release conditions. And the court was very unhappy about it, and the prosecutor was very unhappy about it, and the judge made fun of him. So it kind of looks like he filed a restraining order in a retaliatory manner, which is not the proper use for a restraining order. So here's the question. Why would a lawyer withdraw 2 days before a hearing? You need permission from a judge to do it. He'll get permission from the judge to do it. But you need permission from the judge to do it because it could be wildly adversely effective to your client to lose their lawyer 2 days before a hearing. that could be a very bad thing, right? Like you had representation and now you don't, and now you have 2 days to find representation, get them up to speed. Very difficult. So you have a couple reasons why you would withdraw from litigation. When you get down the road of whatever matter you're on, you can't withdraw for non-payment. So lawyers will never say non-payment. They won't say that. And the problem with withdrawing for non-payment but not saying it, if someone hypothetically were to do that, is that the client could then complain and say they were withdrawing for non-payment. They're lying on their request to withdraw. And that provides an ethical conundrum for the lawyer, and they could actually get disbarred over this. Like you cannot withdraw for non-payment, especially if you misrepresent your reason for withdrawal from the court. At a certain point, I should say that you can withdraw for non-payment early on in a case, etc. And the nature of HROs is they happen very quickly. Like the whole matter is done typically within a month. And so the idea that where the point becomes that you can't withdraw for non-payment is kind of questionable. But I would think 2 days before a hearing, almost universally, a judge is going to say, no, you can't withdraw for non-payment. Lawyers have plenty of means at their disposal to collect payments. They may want a payment up front, but they have the authority or the ability to put a lien on a house, for legal debts, for example. And so like the idea that you can't get payment out of someone is, it's real, but the court's also like, yeah, you have a bunch of legal remedies you can pursue to try and get this back. So they'll make them do the hearing at least. And then if there's a subsequent hearing, they may permit them to withdraw after that hearing, but just so it doesn't burden the client. But other times they'll allow the withdrawal, and then they may grant a continuance and they may not. So in this case, I showed you the notice of withdrawal. There's another letter, and it says the reason. The reason is for unforeseen circumstances. Unforeseen circumstances is lawyer speak for something I don't want to describe, right? Like not me personally, but something that the lawyer doesn't want to describe for whatever reason. Maybe they think that it'll be prejudicial to their client, for example. Maybe it's personal to them and should remain confidential. But you have these unforeseen circumstances is a reason. There's one other reason they could draw, and typically they would put that on the document itself, and that would be for some sort of conflict client conflict. Sorry, a client conflict where they have a conflict of interest. Maybe they owe a duty to a client or a former client that whose interests would run averse to the person they're representing. There's some in-house remedies to try and get around this, but a lot of times what they'll do is if there's a conflict, they'll just say, peace, you got to find someone else. And it's possible that an initial conflict check doesn't bring up anything, but a conflict arises later in an action and they find out and they go, oh shit, we actually can't continue representation because it would be a violation of our client's rights and our ethical obligations. But typically you would just write that on the report. You would say, oh, there was a conflict. And that's not what's written down. We have this unforeseen circumstances. So what are those unforeseen circumstances? I don't know. I withdrew from a case once due to unforeseen circumstances. And the unforeseen circumstances in that matter were that my client had threatened physical violence against me. They didn't like a legal answer that I provided, and so there was a threat of violence, and I thought at that point I can no longer adequately represent the client because the client is clearly not happy with my representation in that matter. And then, I can't really operate, honestly and effectively if I'm thinking my client who doesn't like a legal answer that I give them, which by the way was the right answer. Like I want to point that out. I was correct on this, but they just didn't like the answer. What they wanted me to do would have been a violation of ethics. I don't think they knew that, but it would have. And so I told them I can't do that. And then they threatened physical violence. And I was like, all right, peace, deuces, done. What other reasons are there for unforeseen circumstances? There, like I said, it could be something personal, right? Like a death in the family of the attorney, for example, or something comes up that they don't want to talk about, is very important, but prevents them from being able to do the hearing. But if it's just a hearing that they can't do, typically you would just ask for a continuance, right? Like that, we talked about this, and they can make a good argument. They could even go in chambers with the judge and say, hey, judge, like here's what's going on. Here's why I need it. And even if, even if opposing counsel opposes the continuance, if it's a good enough reason, the judge is going to grant it. Or maybe if they explain it to opposing counsel, like, look, I'm not jerking you off here. I'm actually, I have a thing and I can't miss it. Like the birth of a child, you can think of a couple things. It's like, I just can't make that date. And I didn't know it was going to happen. Like, your spouse goes into labor. Sometimes the attorney could go into labor or something happens. If they can't make that hearing though, usually you're going to get a continuance. This is, I can't represent this person in this matter anymore. Like, so not because of a continuance, like a lack of a continuance, but they're just unable to proceed in the matter due to an unforeseen circumstance. So we're left with total speculation on what it could be. Who knows? And I'm not going to speculate openly on what it could be in this case. I have no idea. But in a hypothetical, for example, it could be that similar to my issue, right? A client either divulges something to an attorney or asks or requests something of an attorney that then creates a dilemma for the attorney continuing representation and also carrying on their duty of candor, their duty of in regards to zealous representation, which could be a lot of things. But for example, a client could admit that they've done something for an improper purpose. They're like, yeah, in a restraining order case, for example, you could say, I'm not really scared of the person. I just really want them to shut up. If a lawyer hears that, ethically, he should not be able to bring that case into court because he would have a duty to inform the judge that his client is actually not pursuing, because otherwise the attorney is representing that the client is pursuing it for a proper purpose. And the proper purpose of a restraining order is you're harassed. You believe you are actually harassed. It isn't like if you're trying to use it to silence someone, then and a client were to admit that to an attorney, that would pose an ethical dilemma. Another hypothetical would be like a client asks an attorney to lie, for example. And I'm not saying any of this happened. I have no information. None. Unforeseen circumstances is just a very sort of vague notion of what happened. And you can only kind of speculate, but the unforeseeable circumstances that could arise are pretty limited. And so we can use our imaginations. But again, attorneys have a duty of candor to the court. So if a client asks them to lie or demands that they pursue some course of action, or maybe they, ask for some specific outcome that the attorney can't provide. So they say, look, I can't get you what you want. I can't do what you're asking me to do. So we have, I can't represent your interests. So you should find an attorney who can represent those interests. And all of this stuff is remediable, for example. Remediable in regards to a subsequent attorney-client relationship. If they said too much to their attorney, because they say you can tell your attorney anything. You can, but whether or not you should say everything that's on your mind is a different question, because you may create a conundrum for your attorney. I don't know if any of this is what happened here. But what I know is that Aaron's attorney has withdrawn 2 days before hearing. He's likely going to request a continuance tomorrow, or he may have done it earlier today. And like I said, we'll be opposing it because we'll be ready to go. we'll be ready to go. And he should be too. It's not my fault. There was one other thing I was going to say about it, but I don't know if I should. Right now, it's just, it's in a funny place because, again, I don't want this restraining order here. I don't have most of the restraints that I have are no direct or indirect communication, and then not being within 1,000 feet of his address. And I think within 1,000 feet of him. That's generally fine by me. However, he lives in a town where I take my kids to go, like I take my kids into that town to do activities because I live in a much smaller town. So like there's a roller skating place and there's a trampoline park and there's better restaurants and stuff like that. So we go to that city with relative regularity. And I don't necessarily know exactly where 1,000 feet from his house is. His house isn't by most of the stuff we go to, but it could be by something I'm going to, and I might not know. And so I don't want anything like that. I don't want some accidental violation of this to become a violation of, like, I have no intention to see him or go to his house at all. I haven't been to his house since I think April 8th or something like that of last year. And so it's like, I don't have any intention to go there. I don't have any desire to, but I certainly don't want to in criminal charge because I happened to stray within the 1,000-foot limit and like maybe wasn't aware. There isn't like a radius marker around things. Like there's not a line you can walk up to like you're playing a video game. It's like, oh, that's the barrier. You don't know where the barrier is necessarily. And I can't get a tape measure and go to the house. I guess I could go on an app and like try and draw a radius and then figure out what that is. But that's crazy. I don't need to do that because I'm not going to harass him in any way, in any capacity. So there's that. Also, the direct or indirect contact gets really complicated with the way some sites do social media, so the way some social media sites function. So I don't need any of this shit hanging over my head. And again, he has no basis for it. So it'll be opposed quite a bit. The thing with it being frivolous is like, now you've cost me time, money, effort, stress, whatever. It's not super stressful. I'm very confident that we're going to come out victorious on this, but you've cost me all these things. Thank goodness. Minnesota has some rules to allow me to recoup some of those costs, but it's a long shot. It's a long shot. So this is a big problem with the American legal system, is that there is a ridiculous ability to cost someone a significant amount of funds to deal with something that they didn't invite. Like if you're willing to just lie about someone, you can lie. Don't do this, but you could lie about someone and get a restraining order. Like you can just lie about it. Lots of people do. And then, a lot of times those restraining orders go unchallenged. And so then they get implemented. And then this person has a sword hanging over their head for 2 years, for example. That's crazy. But if you want to fight it competently, you end up having to hire an attorney. It could cost hundreds to thousands I guess it could cost tens of thousands of dollars. You have to gather materials. You have to do all of this shit that takes away from your peaceful life. And so like I said, there are some tools to attempt recovery, and I'll be pursuing them to the maximum. But with that, that's the main bulk of the update, is that his lawyer withdrew. We'll see what happens. Oh, there's a little bit of speculation I wanted to do. So some people are wondering, the one other thing happened kind of behind the scenes that I want to tell you guys about. This isn't in any documentation, but it's also okay to say. Aaron's attorney had submitted exhibit lists and witness lists on Friday, right? Or Thursday, maybe. One of those two. But nothing actually, none of the actual evidence that was mentioned or referenced in the list was provided in the evidence system, Mindes. That happened today. So there's this weird overlap where the lawyer apparently uploaded all this stuff to Mindes and then withdrew. So the evidence from the exhibit list is apparently available. I haven't seen it yet. I'll see it tomorrow and be going through it. That's my fun is to go through that. But there's this really weird moment of contemplation, like, wait, so the lawyer uploads all this stuff and then withdraws? What does that mean? What I think actually happened is I think the lawyer uploaded everything either late Friday or on Saturday or on Sunday, and that things were accepted into the Mendez system by the court administrators today, prior to him filing the withdrawal. And so I think that's what it was, but I don't actually know. It's really frustrating because, like, why would he upload all this stuff and then withdraw? That doesn't make any sense. And then the question would be, well, like, was that an intentional thing? Because I mentioned that there was a settlement offer a while back. There was a settlement offer to resolve this matter. My response to the settlement offer was get and remains get. But it's possible, for example, that a client could hire an attorney to attempt to resolve something through settlement, but if they're not able to resolve it through settlement, have the attorney withdraw. Like, maybe they think that they could, regardless of their ability to negotiate, maybe they wouldn't be able to negotiate with the other party or the other party's attorney due to something, like maybe some animosity, right? Like, maybe that's possible in an HRO situation. So they might hire an attorney, for example, to try and facilitate the negotiation between the two parties, because they think, oh, well, if there's an attorney there, the two attorneys will be able to have a productive discussion, even if the two parties may not be able to. That's not going to happen with me. If you file a frivolous HRO, you're not getting a productive discussion. You're going to get me saying "F you." That's all that's going to happen there. But in a hypothetical situation, maybe that's what you think. And so then perhaps there is another thing you could hire an attorney for, is to help you prepare evidence and utilize the attorney's access to the electronic filing systems to get things filed. Maybe that would be, and then the attorney would withdraw. That's not an unforeseen circumstance, though, and I don't think an attorney would write down, like, I know attorneys lie, don't get me wrong, but they're usually more subtle about it, and they usually aren't risking their bar license for maybe like $1,000 to $5,000 that they might be getting. Like, it's just not worth it to do it for that. So they're probably not going to lie on their withdrawal reason, being like, actually, no, he just hired me for a limited purpose. He would just say that he hired me for a limited purpose. He probably would not have filed. Well, he might have filed a certificate of rep and then a certificate of withdrawal, but he should have done that earlier if he was going to do it. 2 days is just not enough time to do that. And if a lawyer wrote that down, like, was honest about it, again, that's not a commentary on the instant situation. I don't think that's what happened. But if a lawyer was engaged in that and was honest about it with the judge, I think the judge would actually make them stay on as represent the party. The other possibility, there's one more that I really didn't discuss, and that's that Aaron fired him. That's a possibility as well. Aaron could have fired his attorney for any number of reasons. He could have said, I want you to pursue this. The guy's like, no, that's not the right track, or that's not what we do, or I don't recommend it. I think that's damaging. And Aaron could have fired him. He could have been like, no, either could have been angry, like, I'll fire you. Or he could have been like, okay, well, like, I got to let you go, man. I got to find something else. Either of these things is fine. There's one more document. Oh, I posted it. That's weird. And I'm sure that, like, it's not recommended for me to talk about this stuff, but I don't care. I don't give a fuck. I have the right to talk about it, for one, but it's more that people would say you shouldn't talk about this stuff because it's a discussion of legal strategy. No, I'll be open and overt about this. I am going to walk in there and I'm going to sledgehammer the HRO over and over and over again. I'm going to oppose any continuances because the whole thing is bullshit. And I'm going to point out something right now that strategically I shouldn't point out, but it's a very interesting thing. And so I want to point it out. People are asking, like, what happens, will he get another continuance or not? I've mentioned, if they ask for another continuance, then I'll be opposing it. And here's why I say, if they ask for another continuance, here's the letter. Dear Court Administrator, I'm writing to formally notify the court of my withdrawal as legal counsel for Mr. Aaron Imholt in the matter concerning the harassment restraining order hearing scheduled for July 23rd, 2025. Due to unforeseen circumstances, I am unable to continue representing Mr. Imholt in this proceeding. So again, not at this hearing, in this proceeding. If it was at the hearing, something could be worked out. In light of my withdrawal, I respectfully request that the court consider granting a continuance should Mr. Imholt seek one. This would ensure that he has adequate time to secure new representation and prepare his case, thereby preventing any potential prejudice or disadvantage. I have informed Mr. Imholt of my withdrawal and advised him of the importance of promptly obtaining new legal counsel. I'm committed to cooperating fully with any new attorney he may retain to facilitate a smooth transition. Thank you for your attention to this matter. Please do not hesitate to contact me should you require any further information or clarification. Did you catch that? Consider granting a continuance should he seek one. If I were withdrawing from a case anywhere near a hearing, I would ask for the withdrawal or ask for the continuance at the same time as I file my withdrawal. I would ask for the continuance from my client. Like that's what I would do. Why doesn't he? Why doesn't he ask for that continuance? Should he seek one? Maybe Aaron said, no, I'm going to go do this myself. I'll do it right. He's like, yeah, you might want to get new counsel. And if you do, you're going to need a continuance. It's like, nope, I'm going to go do it on Wednesday myself. Maybe that's what he's going to do. I don't know. Maybe that's his plan. Maybe the parting was hostile. It's possible. It's possible that the parting was hostile. He's just like, whatever this dude wants to do. I don't know. I have no idea. But I found that very, very curious that he didn't just request it straight up. Like that's what I would do. I would just request it. Man, that's great. So anyway, I just wanted to, I wanted to show you guys that that's what went on today. I had a grin from ear to ear for pretty much all of the day because of it. Cause it was just, it was so unexpected and completely insane. My spirit to yours says, saw a clip of Aaron looking at camera and asking you, if you look in the mirror, calling your girl shoulders and said you intimidate no one. This from a guy that's scared of you. This is silly and insulting to anyone that truly needs an HRO. Yeah. First of all, yes, I look in the mirror at my shoulders all the time. I marvel at them. I say, those are lovely feminine shoulders. God, I've always loved women's shoulders. So why wouldn't I like mine? I do that constantly. He says that I intimidate no one. Cool. I'm not trying to. I don't want to intimidate people. I don't know. This is should be pretty evident of my character throughout the years. Intimidation isn't really like a thing that I do very well. I'm a slight, slender little twink. So I'm certainly not like physically imposing in that way. I am physically imposing in the sense that I'm tall and, though I am slender, like just my overall size, like height mostly makes me appear larger than some people, right? Like because I'm tall, I weigh like 170, 180 pounds to 180 pounds at any given time right now, maybe more because I'm kind of fat. But in that case, so I'm like, if you're talking to someone who's like 5'4" and they're 125 pounds, that might be intimidating. I don't know. But I don't like try to be intimidating to people. It's not my thing. Winston Smith says, how can someone used to be a lawyer? A lawyer is someone who graduated law school. I know a lot of people have been saying that like, you're not a lawyer anymore. It's like, no, I'm just not licensed to practice in Minnesota. Currently, my license is suspended. I'm not licensed to practice anywhere. In theory, I could actually go and apply. Like I'd have to tell the state that I was not in good standing in Minnesota and why. But in theory, I could go apply in another state to take their bar or be admitted under a different rule, for example. There's nothing preventing me from doing that. And there's nothing currently preventing me from pursuing the reinstatement of my license in Minnesota, except time and money. And so like, I'll get to those eventually. But yes, it's a weird thing. But it's a thing Sean has given into because Sean has tried to become the darling of Kiwi farms. And so all of Sean's opinions are whenever there's an issue that the sector is at all concerned with, all of Sean's opinions are sculpted with a bias towards, guzzling the farms. He thinks he can do it. Sean, you can't do it. It's temporary in nature. And it's usually because the person that you're aligning with the farms against, like their interest is that person, and you become like this, an accessory that they can use to get a reaction or an opinion or whatever they want, but it's related to the target more often than you. And so he's tried to become a darling of the sector and Kiwi farms and all that. And who knows what he's done, like who knows how much underage futa he has sent to Josh Moon. But that said, he's adopted this thing where they're like, you're not even a lawyer anymore. It's like, well, no, I don't practice, and my license, I'll get it back eventually. It's just low on my priority list because I have a bunch of other shit that I need to fix first. But yeah, you're right. Actually, though, when I got my license suspended for failure to keep up with my continuing education, I actually forgot how to do everything else, and I forgot all the legal concepts, and all my analysis is now immediately wrong. That's actually true. John O'Reilly says, given that facts to support petition were all known on 626, witnesses and evidence have been identified and the issues are narrow, how much prep time for new counsel is needed? I don't know, because I haven't seen the uploads into the evidence system from their side. Like, I don't know how much stuff there is. I don't know how much, they'll have their stuff to go through, and then they'll have our stuff to go through. And I can't say. But let's say there's 40 hours of video, right? Well, then you got 40 hours that they need immediately. I don't know how up to speed new counsel needs to be, but you can kind of just get an idea, like based on how much shit was submitted, how much time they would need to catch up.